little difficulty with some of this because as I read the statute, and perhaps I read it too restrictively, the arbitrator is not limited in the case of mandatorily ordered arbitration by the court's determination that the matter is $15,000 or less. In other words, in the mandatory situation, the arbitrator can enter an award in excess of $15,000. I think that this last year we also saw an assembly bill come down that changed the rule for stipulated arbitration, so that even where the parties stipulate that the matter is $15,000 or under in controversy, the arbitrator is not prohibited from making an award in excess of $15,000. However, I do not believe that the arbitrator has the power, under the way the statute currently is written, to give an award in excess of $15,000 in a plaintiff selection case, because the plaintiff must agree in making that election that the award is not in excess of $15,000. There has been legislative action in the other two areas. There has been no legislative action in this area. So my unofficial position is that I don't think the arbitrator can award over $15,000 in the plaintiff selection.
That's a lawyer's quibble in any case.
A couple of other things to mention is in this area of trial de novo. It gets back to what happens when you demand your trial de novo. And there's no magic about that, but again, you should consult your local rules to find out whether you have to file another at-issue memorandum or not at the same time that you put in your request. Local rules are probably going to vary on this. Some may permit you to do it by letter. Some may require you to file a particular document. Some may want that document plus an at-issue memorandum. Check it out. Once you've filed your request for trial de novo, you are restored to the civil active list, and you are supposed to be put back in the same position as if you had never had an arbitration. Or, as a matter of fact, you may be given some priority and some preference on the next setting calendar. Once you've filed your request for trial de novo, there also shall not be any further reference to the arbitration hearing, or to the fact that there has been an arbitration, or to any of the evidence adduced at the arbitration, or to any other aspect of the arbitration proceeding, until you are through with your trial de novo. If you refer to the arbitration proceeding during your new trial, that's grounds for a mistrial. Take a look at CCP 657 and CCP 1141.25. However, of course, after the new trial and after the jury's verdict is in, then the court is going to take into consideration the existence of the arbitration and the arbitrator's award with reference to post-trial sanctions. And I think you were going to talk about that, weren't you, Norm? Or was Alex going to talk about that?
Well, I wanted to talk for a minute about the trial de novo feature of arbitration, and comment first how little we really know about it, or at least what a very small sample we have of cases which, after the arbitration was concluded, got back on the civil active list and went to trial. You might recall the numbers again. We have 100 cases come into the arbitration pattern. 50 of them are going to settle before the case goes to arbitration. Of the ones that do go to arbitration, a quarter of them are going to ask for a trial de novo, or say in rough numbers, out of the original 100, 12 of them are going to ask for the trial de novo. Now that's still an alarmingly high percentage, when our first estimates were that it would probably be somewhere between 3.5% and 5%. So far, very, very few cases have gone to trial. The experience in San Diego, however, was typical to that already recorded in Los Angeles and Santa Clara County, among other places, namely that the trial de novo is a loser's game, at least at this point, in the experience on the elective stipulated arbitration. They had 6 cases that they tracked to judgment. The total amounts of the award were somewhere in the area of $15,000 divided among those 6 cases. The trials de novo for those 6 cases took a cumulative total, I think, of 15 and a half or 20 jury days or 5 court days, and the total amount of the judgment was something in the neighborhood of $12,000. So this elaborate expenditure of counsel's time and the client's time and the facilities and time of the courthouse produced a negative result. And as I said, that's been indicated as a probable result elsewhere. And perhaps our first estimate of the amount and numbers of cases going to arbitration is not too far off. And it's important that it not be. I think what we lose sight of sometimes is that arbitration is only one way of resolving disputes short of going to trial. We know, for example, in personal injury cases that something like 97% of them are never going to get in front of a judge on the way of its being terminated. And that this percentage of cases going to jury trial decreases every year. But for the enormous number of filings, the dispositions by trial are very small. And that competing devices for the solution of litigation are as important as arbitration is. And how arbitration fits into the scheme of this thing is one of the most interesting features of the experiment, but one thing we really haven't fully canvassed yet because of the limited supply of information that's so far been generated. Well, I think post-trial sanctions is the subject now. If you go to the trial after a case award has been made under the new statute, you won't get away scot-free as you could before. Before, that is under the first 3 years of operation, either party could ask for a trial de novo, and there were no strings attached. You went back on the civil active list, and the case was processed as if no arbitration had occurred. A modest sanction has been approved in the statute, namely that if you don't improve your situation in the trial de novo, you won't get costs. You may pay the other side's costs, and you may likely be stuck for some expert opinions services that were made necessary after the time of the award. I think if you want this lawyer's guess, and I suppose our guess is as good as anybody's, this would withstand the constitutional challenge, our Constitution providing that the right to jury trial is inviolate and shall be preserved to all. But how far you can go on putting limitations on this right to jury trial is probably a question of degree. The attorney's fee sanction is very often mentioned and was mentioned in the course of this legislation, although not very seriously. A bill introduced in the last session of the legislature to impose such sanctions didn't get anywhere, and the provision was deleted at an early point. But people who are earnestly determined to enhance the finality of arbitration take strong views about the necessity for an effective sanction to prevent these cases from being arbitrated and then tried at a net loss of time and money to everyone. The other sanctions are listed here. You have to pay the arbitrator's fee to the county, and there is also some exceptions made on the basis of economic hardship. Norm, you want to cover that?
Yeah. As Alex has mentioned, the requests for trial de novos are going to be looked upon rather unfavorably by the court. There was a judge, Superior Court judge of this court, is saying that there will be no trial de novos in my court. For a plaintiff, there may be a way around the trial de novo request by the insurance carriers. And that's based on a new case called the Royal Globe case. Prior law was that insurance carrier must act in good faith toward its own insured. That sort of was a black letter law prior to the Royal Globe case, which changed the law and said not only does an insurance carrier have to act in good faith toward its own insured, but act in good faith towards third parties as well. And I know of instances where a trial de novo was requested by an insurance carrier, and the plaintiff then sent what we call a Royal Globe letter to the carrier stating that they feel that the carrier is acting in bad faith towards a third party. And in some instances, the carrier has then paid the award. So you might give that case some consideration.
I have a little difficulty in sorting out the standard bad faith letter from the standard Royal Globe form letter. However, I'm sure that I will be seeing a number more of those. Before you draft your standard Royal Globe bad faith letter, be sure and read the case. It does place some rather stringent requirements, I think, upon an insurance company, but it may not be the total panacea to immediate